against the Judicial and Legal Service Commission.
Yes, Mr. Benjamin.
Good afternoon, my lord. May it please you, I, together with Mr. Ian Roach, who is to my left, appear on behalf of the appellant, and my learned friends, Mr. Peter Knox, Queen's Counsel, Mr. Robert Strange, and Mr. Philip Judd, appear on behalf of the respondents. My lords and my lady, there are two interlocutory appeals before you. Given the shortness of time, I propose to begin by just outlining my propositions and then diving straight in. I will give a very brief after my presentation.
I think we can just take it.
You've read everything.
Background, yes.
I'm obliged. The Judicial and Legal Service Commission will advance the following propositions. One, the Court of Appeal failed to have sufficient material regard and deference to Justice Harris's considered and detailed reasoning on leave, which the Commission says is to be read, or was to be read, as one with his further judgments on amendment and cross-examination. Two, that the Court of Appeal wrongly substituted their views as to the factual matrix for his views, that is to say those of Harris, and wrongly criticized Justice Harris in his reasoning for failing to be aware of the broader constitutional context. Three, the Court of Appeal prematurely, and we say with respect, inaccurately and erroneously, expressed views in a definitive manner as to the proper interpretation of the minute, for your reference CG7, and did so without taking account of the factual context, in particular of the Commission's evidence, and failed to exercise proper appellate restraint in expressing those views. Further, the Court of Appeal, we say respectfully, erred in expressing views as to authority, that is to say whether or not the statements and or the conduct of the Chief Justice were binding upon the Service Commission, and did so without having regard to whether in law, on the respondent's version of the Chief Justice's statements, those statements could be regarded properly as being ultra vires and therefore not binding upon them at all.
Hang on a moment. I mean, how many propositions have you got?
7.
7. Well, let's have a proposition.
That's 3.
Okay, for 4 so far.
Sorry, my lord.
Okay.
Yes, proceed. This is really an overview.
Yes, I understand that, but remember, we're not deciding anything final.
Yes, absolutely.
Nor was the court below.
Yes.
So anything they said was provisional on what would be decided in due course.
Yes.
So anyway, let's have your proposition.
So 4, misapply the accepted precedent on amendment, which is to say the decision of Graham in the Court of Appeal, as applicable to either an alleged or deemed decision, and wrongly concluded that the minute reflected a new or nuanced decision of the Commission. 5, disregarded the impact and consequence of the respondent's case on inferences on its applications for amendment and cross-examination. 6, in its conclusions, the Court of Appeal failed to have regard to the respondent's reply evidence, it's not mentioned at all, and failed to specify how the denials in that evidence provided a cross-examination agenda. And finally, 7, the Court of Appeal erred in failing to apply the case law in public law and cross-examination, in particular the decision of Manning and Sharma, which is set out in our case, in deciding that it was necessary, we say wrongly, to have cross-examination to resolve the legal question posed by the respondent's claim, which is in essence whether the Commission acted improperly and or unconstitutionally in procuring the respondent's resignation. So, my lord, briefly on the facts.
I mean, can we cut through this a little?
Yes.
Because it does sound awfully complicated the way you put it with respect.
I
mean, we've got a question about the amendment.
Yes, you do.
And I don't quite understand why you're so fussed about the amendment. it raises another way of putting the case, but
Yes.
that can be gone into a trial. Well, what's the problem?
Our answer in relation to the appeal on the amendment is that we say firstly that the Court of Appeal misapplied Graham.
Yeah, but
As to-
forget about all these cases. It does come down to the practicalities.
Yes.
All the amendment does is to put in a slightly different way. The way arising out of the minute, which by that time they'd received, of their putting their case.
Yeah.
I mean, either it's wrong or right, but it can be dealt with at the trial.
My Lord, in essence, our response in relation to the appeal on the amendment is as follows. That at the heart of the application to amend is an attempt by the respondent to raise the following case. That is to say, that the Commission, by way of a threat, sought to procure the resignation of the respondent, and that threat amounted to the following: that either she resign or they would make a representation to the President to begin the 137 process.
Yeah.
And so what we say
That's her case. May be right, it may be wrong.
Absolutely, my Lord.
Why can't that be gone into a trial?
We say that the correct approach to whether or not that amendment should be entertained was adopted by Harris. That's one. Firstly, that her case was open to her as originally framed. That is to say, if the heart of her case is that of a threat, he says in his decision that it's fully covered by the original articulation.
But I thought the original articulation was a different threat, that the decision had actually been taken and that she would be removed if she didn't resign.
In fact, my Lord Sales, the case as originally framed is that they would revoke her appointment.
Yes.
Not
Start a new process.
as opposed to starting the 137 process.
So what's the difficulty about pleading a case based on the Commission's evidence?
Yes.
Which she says gives rise to a different threat. She might lose on the facts in relation to her primary case, which is the bigger threat, if you like, which is we've decided to remove you, you must resign now, or we will do that.
Yes.
The lesser threat is the newly pleaded one, which is you must resign now, or we'll trigger the Section 137 process.
Yes.
I'm having difficulty in seeing what's wrong with allowing her to raise a lesser case, which may be the only one that she succeeds on at trial.
Yes.
And is based on your side's evidence, she says, and would seem to be an arguable case.
Yes. So there are two answers to that. The first is that we say it's not based on our case. Our case is to be found in our evidence, which is unequivocally that A, that there was no threat, and B, even if that's an issue to be decided, whether or not anything that was said, even on our version of what was said. And then secondly, we say that her evidence, unsupplemented and unadded to, is contradictory of that alternative case. So that in the usual case, for any litigant coming to court, would be that you have evidence in support of the alternative ways that you want to run your case. The respondent in this case has chosen not to adduce any further evidence in support of this alternative way of putting the case. That is to say, she advanced her application for amendment on the basis that it was not necessary for her to adduce any further evidence. And so we say that her evidence is in contradiction to this alternative way of supporting the case, and therefore the judge was right to say, A, it shouldn't be allowed, but in any event, he was open to her arguing by way of inferences that the threat that she was complaining about didn't matter whether it was, as my Lord Sales put it a moment ago, the stronger version of the threat or the weakened version of the threat.
But if she's allowed to run that case, why can't she amend to spell out that a different way of putting the case?
Well, my Lord, I've given the answers that I have. I don't think I would advance my case by repeating any of them.
Yes, thank you.
So that's the fundamental basis upon which we say that Justice Harris took the right view.
Yeah.
Firstly, inferences, cases open to her. Secondly, contradicted by her own evidence. Thirdly, not supported by the respondent's evidence taken as a whole.
But I mean, you're not prejudiced in any way by that case being spelled out. You can deal with it at trial.
It is likely that there might be some consequential further orders that need to be undertaken. In other words, further evidence from us. And the most significant prejudice we see by both the decisions to permit amendment and cross-examination at this stage is that the expedition of the adjudication of the matter has been delayed.
Yeah. But that's all been delayed, but it's all coming here. Should we go on to the cross-examination point then, which is probably the more substantial?
Yes, my Lord. Well, my Lords, can I just give you a quick outline of 2 or 3 facts that we think are important to us as far as the Court of Appeals decision is concerned. Now, my Lords and my Lady are well aware that over the very brief period of the 11th of April to the 27th of April, the Chief Justice was in communication with the respondent in relation to the state of her parthoods. That communication began on or around the 10th and the 11th of April 2017, when the Chief Justice sought to ascertain from the respondent what was the state of her parthood list, because she was about to be sworn in as a High Court judge, and there were questions being raised in the public domain about her appointment at a time when she had matters outstanding. In response to that query, she provided the Chief Justice with a list of some 28 matters.
May I just be clear? These were all part-heard cases, were they?
Correct, my Lord.
Right.
Yes.
Thank you.
The majority of the 28 consisted of paper committals with 1 or 2, I think, summary trials. Secondly, on the 19th of April, before the acting chief magistrate, one of the respondents' matters came up for hearing, and that involved a defendant whose name is Abu Bakr, well known in the precincts of Trinidad because, of course, of his involvement in a coup some years ago. That was not one of the cases that, when specifically asked by the Chief Justice in the course of his telephone conversation and subsequently in her list, that the respondent disclosed to the Chief Justice. In other words, at that stage, it was withheld. On the same day, on the 19th of April, a number of journalistic queries were sent to the judiciary inquiring about the state of the respondent's list. And if I can, just for completeness, invite my Lord's attention to the relevant paragraphs of the respondent's affidavit. Can I ask you first of all, and I'll do this very briefly, can I ask you first of all to look at volume 2, electronic page numbering, page 580. I'm inviting my Lord's and my Lady's attention to paragraphs 24 and 25.
Yes.
And 580. My Lords will see what I just summarized as the matter against Jamaat al-Muslimin leader Yassin Abu Bakr, which had been parted by me as Chief Magistrate, came up for hearing before the acting Chief Magistrate in Port of Spain. The matter was adjourned by the Deputy Chief to receive instructions as to how to proceed. This resulted in criticism by members of the bar who voiced concerns about the status of the matters. Paragraph 25, on the 19th, same day, I received an email from Ms. Carter Fisher, Court Protocol and Information Manager, bringing to my attention certain questions raised by a journalist in relation to the matters parted by me. I responded to her questions. She then sent me a draft release to be issued by the media, by the judiciary, in relation to the questions asked. I reviewed the media release, which was subsequently issued by the judiciary on the evening of the 19th of April, 2017. It stated at that time that I only had paper committals for consideration, which could be continued by another magistrate. So just pausing there, the Abu Bakr matter was not a paper committal, it was a summary trial. It also specifically addressed the status of the matters involving the Jamaat leader, the media release, the contents of which were not denied by the Commission, also advised that the Deputy Chief Magistrate would act in the post of Chief Magistrate until appointment by the JLSC. And then she refers to the press release. Can I, for the sake, again, of completeness, on the very same point, invite your attention to page 8010, that's 810. I'm asking you to look at the affidavit of the Chief Justice where he deals with the very same factual issue. So that's volume 2, page 810. And I'm inviting your attention to paragraphs 29 and 30. Trust my lords and my lady have it.
Yep.
Paragraph 29, I received a draft press release from Ms. Carter Fisher, as there were now several journalists who were asking questions of a similar nature. The draft release was copied to, among others, and the persons are identified. On the 19th, paragraph 30, at 11:52 a.m., the claimant responded by email and suggested what she thought should be in the press release. Ms. Carter Fisher redrafted the press release and sent it back to the claimant, to the deputy and me. And they're now produced and shown to me. And I just want to ask you to have a look at those documents, which is...
Sorry, what's this go to? I mean, this is a particular instance.
So this goes to the factual background, which informed, or in fact more particularly did not inform, the Court of Appeal's interpretation of the minute. So I'm going to demonstrate a connection between...
Yes, but we're not going into the interpretation of the minute.
Well, absolutely, my lord.
We're asking about whether there should be an amendment of the pleadings and whether there should be cross-examination.
Yes, my lord. And I entirely accept that, except that in their judgment, at paragraphs 37 to 39, and in previous paragraphs 18 and 19, the Court of Appeal actually spent considerable time analyzing and construing the minute as a basis for doing the following two things. A, as a basis for criticizing the first instance judge as having the wrong approach to the application to the amendment and cross-examination. And B, on the basis of that criticism, you use it as a means of saying they're entitled to come to their own view. So that's the reason for it.
As you better show us where in the judgment you say they went wrong.
They come to yes.
They're only saying it's arguable at this point, aren't they?
In relation to the construction of the minute, I think what they say, my lady, is...
It's electronic 507, isn't it? 1357, the paper.
Bear with me. So at paragraph 30...
This is bundle 2, page MS, electronic page 507.
507. So, their discussion, my lady is right, at paragraphs 36, 37, 38, 39, they express certain views as to what the correct construction of the minutes is concerned.
They say that's arguable.
They say that it is arguable with a reasonable prospect of success at paragraph 36 that certain things were communicated, and then at paragraph 37, the language of arguability does not appear. What is arguable is their construction. Here's what they say. When one examines substantively the three decisions of the respondent, one sees that it's eminently arguable that a clear and unequivocal decision was that the information triggered and met the threshold of disciplinary inquiry, or for disciplinary inquiry. This, one may argue, was the primary decision. However, because of the need for expediting of the appellant's outstanding part-heard matters, two further and consequential decisions were made. The first of these two consequential decisions was to give the appellant the option of withdrawing from the High Court bench and returning to the magistracy to complete her part of matters. The second was contingent on the failure of the first. So all that we say about all of that is that in coming to its conclusions, albeit provisional, in relation to what the minute meant at paragraphs 37, and it continues on paragraphs 38 and 39, is that the Court of Appeal did not have regard to the respondent's evidence which set out the factual context.
But, I mean, my lady is surely right that the Court of Appeal is only saying this is an arguable case.
My Lord says you get no resistance from me on that proposition. All that I'm saying at this stage, in other words, what the Court of Appeal had before it was not simply the evidence of the respondent. And at this stage of the proceedings, it also had before it the evidence of the appellant. And in deciding how it was arguable, not whether it was arguable, how it was arguable, what we say is that the court properly ought to have regard to all of the evidence. That's I don't go any further than that. Not for the...
I mean, anything they've said on this is provisional.
Yes.
And at the trial, you'll be able to put the full points in front of the judge, and the sooner we get on and do that, the better. And I simply don't understand the point of us having a great argument about whether they should have been firmer about some point or another. The question is why we can't get on and have a trial. You know, what's the point of this argument? I mean, this is simply on the amendment at the moment. We're simply talking about the amendment.
Yes, my Lord, we are.
And you accept you're not prejudiced by it, so...
I did accept that.
Well, what about the cross-examination point? Because that's probably more substantial.
I'm obliged, my Lord.
They decided the judge had failed to understand that there was a significant difference of evidence, a conflict of fact, which needed to be resolved by cross-examination.
Yes.
And what was wrong with that?
Oh, well, we say most respectfully that the Court of Appeal leveled a number of criticisms. One of those was that there were differences or disputes on the facts, and our respectful submission is that the resolution of those differences was not necessary to enable the court to answer the legal question that was posed by the respondent's claim. That is to say, whether or not her resignation was unconstitutional or otherwise illegal. Secondly, we say that the Court of Appeal, unfairly criticized the learned judge for failing to have regard to the broader constitutional context. And you will... I
mean, just take... we've got this statement of fact, and which very helpfully sets out at paragraphs 9 and 10 what the differences were. I mean, it says that her account was set out in paragraph 9, and then paragraph 10 it says the Chief Justice has disputed her account, and goes on to set out his account.
Yes.
Now, there are two different approaches to what actually happened. How can one resolve that without cross-examination?
Well, we say that her attack on, first of all, the minute goes nowhere at all. And so in essence, there are two bases upon which the respondent takes issue factually. And the first is, well, what was decided on the 27th of April? And the second is what was said by the Chief Justice on the 27th of April following that meeting, and what was said by Ms. Pear and, to a lesser extent, Ms. Rodriguez. So if I can take, first of all, the differences as to the decision. I did tell you a moment ago, and I would just like you to have a quick look at it, that the decision it's reproduced, but it's to be found in the affidavit or annexed to the affidavit of Ms. Gulab Singh. So that's volume 2, pages 9, 5, 7, but in particular 973, 974, and 975.
Are those the electronic?
Yes, my lady, they are. Yeah. So you will find there.
This is the minute, is it?
That's the minute. Now,
And just before we get into that,
yes,
I think it is just worth observing that your two issues have some relationship
absolutely, my lord, they
to
do.
each other.
They do. And in fact, I go further and we say that the two appeals are intimately articulated. But I'm not sure if that's what you had in mind when you...
Well, when you say the second issue is what was said by the Chief Justice,
Yes,
of course, the respondent says that on her account, he was saying that a decision had actually been taken to remove her.
yes,
That was the threat.
yes, that's right.
Now, if she's believed on that, and the court finds that actually the minute is not an accurate minute,
Yes,
that will be one presentation
yes,
of her case.
yes,
We don't know whether that's right without cross-examination. And the Chief Justice says, no, I didn't say that at all.
yes. Did I say?
I said something
Go ahead.
less than that.
Yes,
And what I said is reflected in the minute, and then there's the alternative case put forward, even if that's right. But we don't know whether that's the correct foundation for looking at the case without cross-examination, do we?
my lord, we say that when you look at the way that they have sought to attack what was decided in the minute, all that is said, so I'm leaving to one side just for the moment, what was said by the Chief Justice and what was recalled by the respondent.
But that's why I'm pressing you on this. So
my lord, I appreciate what you're doing, and I'm going to answer, my lord, in a moment.
All right, yes.
Literally, as soon as I finish the next two sentences. But can I just say this, that insofar as there is an attack on the content of the minute, there is no, as it were, basis any longer for saying that the minute is not reliable, because there were two bases that were advanced. One was that it was an undated and unsigned minute. And the second was that insofar as they sought to cross-examine Ms. Gulab Singh, they were cross-examining her on the basis that she had not produced contemporaneous manuscript or audio recording of the meeting. And we say that was all taken care of the moment that, in answer to their application for disclosure, a signed, confirmed version of the minute was produced, which answers the following queries. It is dated, it is timed, it is signed, and it's to be found, again, just for completeness and comparison, at volume 3, 1411, I think, yes. Volume 3, pages 1411, 1412, 1413, and 1414.
But as I understand it, the respondent doesn't accept that does answer her complaint.
Well,
Does she? Isn't she going to say, well, that's not what the Chief Justice told me?
that's right. So, and that's the part, and I'm going to deal with that now.
All right.
So that as simply as far as the documents are concerned, and insofar as there was what I would call a narrow documentary challenge, I say that what is to be found at those pages that I've drawn your attention to disposes of it. And that material was before Justice Harris, and he had regard to it, but and it was also before the Court of Appeal, and they had no regard to it whatsoever.
Yeah, but you yourself accepted that your two issues are related.
Yes,
what
Lord,
was decided? And since the second issue, I would have thought, plainly depends upon different accounts of what happened at the meeting between the respondent and the Chief Justice, as to which, if one needs to resolve that, you will need cross-examination. And since you accept that the resolution of that may itself inform the findings the court may ultimately make about what was decided on the 27th of April, at the moment I'm not following how you can say that you do not need cross-examination to resolve both these issues.
Right. So, my Lord, I'm now going to come to what was said by the respective parties. So that in this case, we have a single speaker. That is to say, we have the Chief Justice, who is a single individual who is alleged on the case of the respondent giving one account of what was discussed on the 27th with him, and then we have the respondent giving a different account as to what she was told if you drill down to the specifics of the differences, she essentially says two connected things. The first, she says, on her recollection of what she was told at that meeting, was that the Judicial and Legal Service Commission had decided to revoke her appointment. And we say, for obvious constitutional reasons, that is an incredible version of events. But putting that to one side, she is not in a position, to identify what it is that the commission would have decided earlier that day.
Well, she is, because she's told,
yes,
on her case, she's told by the Chief Justice.
All that she can say, and her case does not get any stronger or any better than this, is, I was given a different account by the Chief Justice. That has to be weighed up against the Chief Justice's account, in respect of which there are, on the basis of this appeal, the moment before the court, a limited attack by way of cross-examination. So that is to say, a limited attack on the appellant's account of the evidence, so that in the course of that meeting, the following individuals have given an account of what was decided. That is to say, Ms. Gulab Singh annexes the minute, Justice of Appeal Stallmeyer gives an account, and Chief Justice Ivor Archie gives an account. The application and the order for cross-examination directed by the Court of Appeal is limited to specific paragraphs of Chief Justice Archie's account of that meeting. There is no application, live application, nor is there any order for cross-examination of Justice of Appeal Stallmeyer. My learned friend and I have a slight difference of opinion as to whether that is so. And can I just answer that suggestion by inviting you to the decision of the Court of Appeal? Can I ask you to go to page 515 and 516 of volume 2? My lady probably had it already. And you will see there that the only deponents to be cross-examined are Chief Justice Archie, Ms. Gulab Singh, Ms. Peer, and Ms. Rodriguez. There is no order from the Court of Appeal cross-examining Justice of Appeal Stallmeyer, who, for the purpose of this conversation, my Lord Sales, in other words, for the purpose of this conversation, in other words, we have the Chief Justice on the one side and we have the respondent on the other, is quote-unquote a third party. He was not present in any of those conversations. But there is his account of the meeting is unchallenged. And so you will have a situation in respect of which there is...
Which meeting? He was at the meeting
he was,
of the
yes.
commission, was he?
Yes, absolutely, my lord. I'm sorry I didn't have an opportunity to make that clear, that the persons who were present at the meeting were as follows: Chief Justice Archie, retired Justice of Appeal Stallmeyer, retired Justice of Appeal Hamel-Smith, and Ms. Gulab Singh as secretary. That is set out both in our written case as well as in the...
So what is your point?
The point is that...
They've limited what the...
They've limited...
and they think they need.
They've limited...
And you say they may not...
I go further with respect, my lord. I say not only have they limited what they need, that by so limiting themselves, they have undermined the utility of the order for cross-examination. Because you're going to have a situation in respect of which a differing account of the meeting is to be found in a deponent who is not the subject of cross-examination.
Well, you think they should cross-examine him as well?
I'm saying that having decided not to cross-examine him, that is the end of the order for cross-examination.
That would have to be sorted out at trial. I mean, we can't go into that here.
They did ask to cross-examine him, didn't they?
And then they withdrew it.
Right.
Yes. And then they withdrew it. And in fact, it is the progressive narrowing and reduction.
But, I mean, you don't complain about the narrowing and reduction.
No, I don't. I just say...
At the heart of it all, we've got a difference of fact, a difference of recollection between the Chief Justice and those who support him and the complainant, and that's got to be sorted out.
Yes, my lord.
Well, what's wrong with that?
No, my lord, we say with respect, and in attempting to answer my lord's sales question, that the observation that I've drawn to my lord's attention demonstrates that the account of what was decided by the Judicial Legal Service Commission cannot satisfactorily be resolved in the way that the respondents seek to do.
So if the point you make is a good one, what's to stop them from, when that penny drops, from then applying to cross-examine the retired Justice of Appeal as well, when they realise that your case will be, well, you have to accept that the minute is accurate because you haven't cross-examined these people. Presumably, the logic of them applying to cross-examine Ms. Gulab Singh,
Yes,
who is the secretary,
yes.
is to challenge her on whether the minute is accurate.
That must be the theory.
Yes,
And-
well,
and I'm
absolutely.
going to-
So they are challenging the accuracy of the minutes. They're intending to do so. What you're saying is they haven't cast their net wide enough,
Yes.
as they will need to do in order to carry home that challenge.
That's right, my lord.
So that's why I'm saying they make, having listened to you, realise, Ms. Benjamin's quite right. We haven't applied to cross-examine all the people we will need to do. And therefore, in due course, we will apply to cross-examine them as well.
Yeah. My lord,
It's quite clear, sorry, just so you have the point. It's quite clear, and you accept, that they are intending to challenge the accuracy of the minute. That's why they've got Ms. Gulab Singh there, as well as the Chief Justice.
my lord, on the basis of the order, yes. Can I just invite your attention to Ms. Gulab Singh, just one further aspect. And it is this.
Just before you do,
I'm sorry, my lord.
was this point that you've just taken, namely that they're bang to rights on what happened at the meeting because they haven't challenged one of the deponents to what happened,
Yes.
taken in the Court of Appeal?
No, my lord. No, it wasn't. Because it wasn't until the very end, my lord will recall, that in my learned friend's written case, he acknowledges that the areas of dispute for cross-examination did not include what I will describe as category H. That is to say, the contents of the meeting at President's House. And the reason and the way that came about, and I cast no aspersions, was because it wasn't until the very end of the hearing of the Court of Appeal that the Court of Appeal asked, please, to counsel for the respondent, please identify the deponents and the paragraphs that are to be the subject of this cross-examination. In other words, in giving that answer, my learned friends and I have agreed that as far as the meeting at President's House, when the respondent went to provide or to hand over her letter of resignation, that was not the subject of the appeal for cross-examination because it had been expressly withdrawn. And that provides me with another occasion or opportunity to say that the withdrawing of the appeal in relation to what was discussed at President's House further undermines the order for cross-examination. Because, as you will recall from having read the affidavits, the respondent's account of the exchange there was that her husband asked the Chief Justice.
My question wasn't about the meeting at the President's
Yes,
House.
my lord, I know.
It was about the meeting of the Commission.
Yes.
And I think you say, no, the point wasn't taken in the Court of Appeal. Is that because nobody knew during the whole of the Court of Appeal hearing who it was that the respondent wished to cross-examine?
No, the way that the respondent dealt with it was only in their written submissions did they decide that they would narrow their focus to E, F, and G. And in the course of answering the question provided by the court, they gave their answer. They did not pursue the cross-examination of Justice of Appeal Stallmeyer. So all I'm answering, my lord, is that there was no opportunity to complain or to take the point, so to speak, that Justice of Appeal Stallmeyer, who was a central decision maker, in contrast to Ms. Gulab Singh, who of course only served in an administrative capacity and whose account of the meeting was no longer being challenged. Similarly, in relation to Ms. Gulab Singh, if I can invite your attention to the to the respondent's application for cross-examination. It's to be found in volume 1, pages 203 to 224. And I trust my lords have it.
It's the table on top of 204
You've got it, my lord.
you're mainly looking at.
So if I can invite my lord's attention. So this was the initial table. And if you scan very quickly, pages 206 onwards, it's common ground between my friend and I that sections A, B, C, and D were no longer being pursued at the level of the Court of Appeal. And that was telegraphed in their written submissions.
I'm sorry, what are you on now?
I was answering my lord's question.
We're simply not going to go into the question of which bits of
Oh, absolutely, my lord. No.
admitted.
I was
Our
merely...
job here at the Privy Council stage is not to case manage in detail.
Absolutely, my lord, yes.
The only issue, I think, as far as I can see it, is whether there was, in principle, a basis for ordering cross-examination in the sense that there
Yes.
was a dispute of fact,
Yes.
and the Court of Appeal thought that the judge hadn't appreciated sufficiently there was a conflict. They decided there was. Now, as to who's going to be cross-examined, if that is established, well, that's a matter to be sorted out locally. We're certainly not going for that here. Now, is there anything more you want to say?
My lord, yes.
Whether there's a dispute of fact.
Yeah. My lord, can I just make a brief response to my lord's observations? It's not correct to say that Justice Harris did not appreciate that there was a dispute of fact between the parties on the respective accounts of these meetings. That's not the basis upon which he refused the application for cross-examination. He says, and he says repeatedly, that there are disputes of fact. His decision was premised on the basis that it was not necessary to answer the question posed by the claim to resolve those differences.
And the Court of Appeal disagreed with him.
And the Court of Appeal took a different view. And we say most respectfully that the first instance judge's case management assessment ought to be respected as being sound, as being factually accurate, because he didn't come to a different factual conclusion from the one that they arrived at. And therefore, the critical question is not whether there are differences of fact, which is what we spent a lot of time on, but whether it was necessary, just, and expedient for the resolution of the matter. My lord, yes.
I mean, you accept that there is a dispute of fact?
Yes, that's part of my written
Well, how is that dispute to be resolved without cross-examination?
Well, my lord, I say with respect that I would frame the question differently. Not whether it is not a question as to how our differences of fact be resolved without cross-examination, because there are differences of fact in all of the categories in respect of which the respondent sought to cross-examine initially.
But they've limited themselves to those which
Lord,
they
yes.
think are most material.
Yes, my lord.
And in relation to those, how can they be resolved without cross-examination?
My lord, my answer to my lord is that the real question is not whether they can be resolved without cross-examination, but whether they need to be resolved in order to resolve the matter.
But you yourself said that the real issue in the case was whether or not the respondent's resignation was unconstitutional.
I did. And I don't reside from that.
The essence of her case is that she was pressurized.
Correct.
And there's a plain dispute of fact, isn't there, between her and the Chief Justice as to whether his conduct and what he said to her when he met her before they went to the President's
Yes.
involved pressure or not.
Yes.
So how can that not be a relevant issue of fact?
Because we say that whatever the differences of the account, and this is the view that Justice Harris took, that her case was opened to her on his account, that is to say on the account of the Chief Justice, as well as her account.
Well, you don't accept her account.
No, my Lord, I don't, but I'm simply putting the analysis for what it's worth.
Sorry, I'm sorry, you go.
No, my Lord, I'm not. So, my Lord, my Lord, Lord Kitchen, my fundamental starting point is very simple, which is to say that the differences of fact doesn't answer the question posed by the appeal.
But it may do. You yourself, as I understood it, accepted when we had an exchange earlier on,
Yes.
that there are, depending on which version of the facts one goes with, different threats. On her case, there's a more serious threat.
Or an emptier threat, depending on my Lord's perspective.
Well, all right.
But, my Lord,
From her perspective,
my Lord, I don't
more
disagree
serious
with
threat
anything you say.
because on her account, she's being told by the Chief Justice, we've already decided you're out. It's as simple as that. You resign now, or
Yes.
we'll find that you're out. I'm characterising that as the more serious threat.
I'm obliged, my Lord, yes.
On the a possible interpretation of what happened on the chief against the background of the minute, the threat on her case may prove only to have been that the Section 137 process had been triggered. She, I think, on her alternative case, the one that she wants to plead, is still going to say, well, if that was the threat, that was illegitimate as well.
Yes.
But clearly, her case is going to be stronger if the first threat is made out, which is her primary case. And in order to see whether that threat was made out, I would have thought you clearly do need to have cross-examination as to whether the Chief Justice did indeed utter that more serious threat.
Well, my Lord,
Her case will be stronger if she's right about that.
my direct answer to my Lord is that while I have to accept for the purpose of argument that her case may be stronger, for the purpose of this argument, I want to reserve my position as to whether or not the making of an empty threat, and all that I mean by that is that this is a constitutional heresy, if I can put it like that, and I think my Lord Briggs is nodding, so I've gone far enough. My Lord, my simple position is this. Strong threat, weaker threat, the court that is deciding the issue has to answer the same question, ultimately, which is whether what was alleged to have happened, version A or version B, amounts to an unconstitutional attack upon the independence of a High Court judge. And so,
But the trouble is that one might and the other might not.
Yeah. Anyway, I think we've been making rather a lot of the running, I'm afraid. You've only got 10 minutes.
Yes.
So perhaps we better let you have a free hand to make any other points you feel it necessary to make. But I mean, you've got the thrust of what my lords have said.
I do. Can I, my Lord, just have a look to see what it is worthwhile attempting to get through in the remaining 10 minutes? My Lords, can I say that as far as the constitutional dimension is concerned, that is to say, as far as the Court of Appeal's criticism of Justice Harris, that he was not alive to the constitutional element, which of course underpins the exchanges that I've just been having with Lord Briggs and Lord Sale, we say that is entirely inaccurate, and I would invite attention to paragraphs 84, 85, and 86 of the judge's decision on leave. Those are to be found at volume 1, pages 138 and following. Just make sure I have it, yes. Pages 138 and 139.
Right.
Insofar as the ground of the case law is, as far as the issue of cross-examination in public law matters is concerned, I rely upon the following decisions. Firstly, that of Manning and Sharma.
But I mean, do they say anything different, that cross-examination is exceptional or unusual, but is possible when it's necessary to resolve facts?
No, they don't.
That's what
And well, my Lord, can I be very clear? that last 5 or 6 words of my Lord's sentence, which is to resolve facts, is not the proposition that I rely upon those cases for. It is to resolve the underlying issues in the case,
Well,
as from my point of view.
that are necessary. For
Absolutely, my Lord. And my Lords, I want to accept entirely, if my Lords and my Lady are against me, and so far as I have tried to advance a submission that it is not necessary to answer the question in the way that I've put it, well, of course, that's the end of the appeal. I'm not running from that, but I want to hold fast, as it were, to my primary submission.
Your point is not so much the principles of cross-examination, but whether it's necessary to decide the points in principle.
Absolutely, my Lord. And again, having regard to the time, in this case, what Justice Harris wished to do, having given his 3 rulings at the end of January 2019, he set out a timetable for the resolution of the matter. That is to say, he directed that there be final written submissions in February and a trial in March of 2019. And what he was doing there was having regard to the following 2 connected things. He was having regard to the importance of the just and expeditious resolution of matters, but he was also so doing in the context of Part 56. Now, it goes without saying, of course, that this is a judicial review application, public law application, and in the ordinary case, these kinds of matters are intended as is supported by Part 56 to be resolved sooner rather than later. And so what we say is that in the exercise of his case management judgment, he made a judgment about necessity and he made a judgment about expedition as well as just resolution. And that when you come to look at, as I invite you so to do, the decision of the Court of Appeal, that they had no regard and there was no mention of the importance in this context of expedition. And we say that in that regard, the Court of Appeal went wrong, and they went seriously wrong in substituting their view for that of Justice Harris. Can I, in the 4.5 or 5 minutes remaining, make brief submissions about what we say is the neutral as opposed to the interpretive reading of the decision to be found in the minute? And I'll do it by, I know that, my Lord, my propositions have been over-elaborate, but I'll do it by a series of propositions, if I may. 1, and this is, we say it's reflected in the minute, that the respondent had more than 50 part-heard matters outstanding. That as of the 27th of April, 2017, the Chief Justice and the respondent had spent 2 days meeting and had identified that the problem of her part-heards needed to be resolved and dealt with. 3, that the number and nature of her part-heard matters raised legitimate issues about A, her prior conduct as a judicial officer in the magistracy, including whether she had misled the Chief Justice, the Judicial and Legal Service Commission, and the public, and in brackets, that's why I drew your attention to the press release of the 19th of April, 2017. But fourthly, the Chief Justice and the Judicial Legal Service Commission properly had regard to the extent of harm to the administration of justice as a result of the state of her part-heards. 5, the respondent has not sought a deferment of her swearing in, as had at least 2 other candidates for judicial office. 6, the information before the Commission was factually based and sufficiently serious to trigger 137, open brackets, see the test in Rees and Crane. 7, the Commission was legitimately concerned, however, to expedite the disposal of the respondents' parthoods. 8, the minute reflects and is consistent with the respondents' account, at least this part of it, that they decided to grant to the respondent the option to withdraw from the High Court bench and return to the magistracy to complete those parthoods. 9, the Commission did not take off the table the possibility that if she declined to withdraw, that they would have to consider whether the 137 process should be instituted. And 10, we say it follows that no final or firm decision was taken to institute the 137 process. So we say that that's the core without, as it were, the conflicting or the contested interpretations, one advanced by, an instance of which is advanced, as my Lady Black rightly says, on the basis of arguability, which gives precedence, or to use the language of the Court of Appeal, they described it as the primary decision. And what we say is that, with great respect to the Court of Appeal, that in this sensitive matter, it was inappropriate for the Court of Appeal to express that view at all. And that properly, they ought to have taken the position that Justice Harris did, which is leave it to the trier of fact and law, which is why he says, when faced with the different quote-unquote interpretations, that it was a matter to be resolved after hearing all of the appropriate all of the submissions. And my Lord, I think that brings me to an end of my running time. My Lord, I'm grateful for the time that you've given me.
Thank you very much, Mr. Benjamin. Mr. Roach, do you want to add anything?
Do
you want to add anything?
Look, just one thing I struck with me, my listening has been sort of like a strong contact, but having traveled this far and contributed to the carbon footprint, I must make this comment, is that what Sales says earlier on in terms of with reference to the amendment, that what is the difference in permitting the respondent to be allowed the amendment? My trouble is that the trial judge who has conduct of trial and is managing his case management duties. So it fits, by saying that he grasps what is the key issue, what is the main issue here, being a threat to have the respondent to resign. And he's saying basically what is captured in that very first case in which leave has been given, there is no need as far as he's concerned to permit a further, as I think you said earlier on, a weaker position of putting her case in a different way. What it has done thus far is use up all of our judicial time by this matter could have been dealt with. I think that the Court of Appeal, as well as the Privy Council, have been very consistent in trying to restrain the higher courts from intervening unless it is very obvious in terms of error.
I think we've got that point, that really the Court of Appeal shouldn't have interfered with the trial judge's careful assessment.
Precisely,
Yeah. Yeah, well, I think we have that point. Thank you very much. Thank you very much, Mr. Rhodes. Thank you. I think we'll rise for a moment just to see where we've got to. So, just 5 minutes. Right, well, thank you, Mr. Benjamin. Thank you very much for your submissions, and Mr. Roach. But I'm afraid we're not with you, and we're going to dismiss the appeal. We think, in the circumstances, the less we say about the detail of it, the better, because it's got to go back, and it's clear that all that's being decided at this stage is provisional in the sense that it will have to be gone into the trial. But it's enough for us to say first that we think the Court of Appeal were entitled to say that the amendment raised an alternative way of putting things which the claimant was entitled to advance, and that the judge was wrong in disallowing that. And secondly, on the cross-examination issue, there clearly were factual issues to be resolved, and the Court of Appeal were entitled to say that they were material for the purpose of deciding the case. And it's, I think, desirable we should say no more than that. So that is our decision. We will dismiss the appeal for those reasons.
My Lord, I'm very grateful for the
Thank you
speed
very
in which
much.
you've resolved the matter. Most grateful.
Mr. Knox, thanks for your presence.
My Lord, there's only one point that arises, whether to deal with it today or otherwise. That's the question of costs.
Yes.
And, my Lords, we would say that we should have the costs of this appeal in any event, and indeed be assessed and paid forthwith after assessment, because this case is still going on, and it's not cheap.
Well, then, are you able to resist that?
My Lord, I don't think I could resist what I would call the order, the usual order, the order
Cost,
that
yeah.
costs follow the event. As far as payment and so on is concerned, I don't have any instructions to answer to any of that. So I'm entirely in your hands. It seems to me to be not the usual order. The usual order is what should happen in this case. And I'm quite certain
Well,
that...
I think we'll simply order that you pay the costs, and that
Yes.
if there's any consequential matters, that have to be dealt with in writing.
Obliged, my Lord. Most grateful.
Now, we're going to be seeing you tomorrow, Mr. Knox, I think.
Yes.
We're not going to be seeing you tomorrow, Mr.
Only at the back, my Lord.
You'll
As a
be-
spectator.
Well, we're very grateful for your assistance,
My Lord, I'm very grateful.
and we all look forward to seeing you in some form tomorrow. But thank you very much.